Hello and a warm welcome to this special conversation. Over the last couple of weeks, we've been reporting extensively on the entire controversy which has been brewing around the cash which was found in big bags allegedly at the residence of Justice Yashwant Varma. Well, today, certain media houses have now published the inquiry committee report. The inquiry committee, the fact-finding committee which was set up by the Supreme Court, the contents of that report have now come out in public domain, and Indira Jaising, well-known lawyer, jurist, also an editor now of the leaflet, her organization has been one of those which has published the key contents of the report. Over the last couple of weeks, we've looked at this story through the angle of what was being stated by Justice Yashwant Varma in his defense. The sum and substance of those findings, according to sources, is that Justice Varma is indeed guilty. So we welcome Indira Jaising today on the Squirrels.in and to figure out what could be really the road ahead from here on. So Indira ji, firstly, this fact-finding committee report, the contents of which have been published on your platform, the leaflet, does it make an open and shut case of corruption against Justice Yashwant Varma?
So let me answer your question by telling you what was the mandate of the committee. One thing you must understand that the in-house procedure is now judicially sanctioned by the Supreme Court of India, and the mandate of the in-house committee is to decide one of three things. Number one, is there a case made out of misconduct sufficient to require the setting up of a judicial inquiry under the Judges Inquiry Act, which inquiry is conducted within the precincts of Parliament. Two, if there is no such case, should the case be closed? This is the mandate of the committee. And the committee has come to the conclusion that the allegations which have been proved by the committee itself require the setting up of an inquiry under the Judges Inquiry Act, which inquiry takes place within Parliament after 50 or 100 MPs have signed a motion to that effect. So the committee has come to the conclusion that a case has been made out for removal with due process of law. So they come to the conclusion that an act of misconduct sufficient for removal has been made out.
But, Indira ji, I was telling our viewers that we've been looking at this case for the last couple of weeks very closely. Let me tell you, ma'am, that we have gone through the contents of the letter, a very detailed 105-page statement which was made by Justice Yashwant Varma before this fact-finding committee. Now, in that letter, Justice Yashwant Varma takes this position that it was his daughter who was the complainant in this case. He takes this position that he's the one who's asking for an investigation, but the fact-finding committee is not going in for an investigation. How do we read this contradiction, ma'am?
Right, I will tell you. See, the law declared by the Supreme Court is that no police officer can lodge any criminal case, namely an FIR, against a judge, stop an IR in relation to any offense committed against any one of his family members or any perceived wrong against him. So the question naturally arises, what stops his daughter from approaching the police and lodging a complaint? There's no legal bar. The converse is true. There is a legal bar preventing the police from lodging any complaint against the daughter or the father.
But Indira ji, I agree. I take your point that the law is such that the police cannot be investigating a judge. But in this case, when the judge takes an official position, as Justice Yashwant Varma has taken in that 105-page letter, which he submitted before the fact-finding committee, if he's asking for an investigation, is there no mechanism of an investigation? Then why hang the judge?
No. His right to have an investigation commences when he decides to lodge an FIR. That's when his right commences. And the committee legitimately asked the question, what prevented him from doing so? Nothing at all. There are mumblings of, could this be a conspiracy? There is a mumbling, could this be arson? Arson is an offense under the BNF, as it was under IPC. Nothing prevents a judge from lodging a complaint for arson or perceived arson. Nothing prevents him from lodging a complaint of conspiracy. And the fact that he did not do so points a finger of suspicion to him.
So, are you saying that the only place now where there can be an intervention or an investigation which can be launched on the basis of what is being argued by Yashwant Varma is only and only Parliament now?
Well, I suspect that he still has the option of lodging an FIR if he wants. But how it will be viewed is a different matter, considering the delay involved. Being a judge, he should know that at the earliest possible crime is apprehended, if a crime is suspected, the right thing to do is to lodge an FIR. But there is absolutely no doubt about the fact that in any inquiry constituted under the Judges Inquiry Act, he will have the full and complete right to defend himself along of any lawyer or lawyers of his own choice.
But at what stage? At what stage does he get that right to defend himself?
Like law, first and foremost, there will have to be a motion signed by either 50 members of parliament in the Rajya Sabha or 100 members in the Lok Sabha. The motion has to be admitted. After admission, the Chief Justice of India will constitute a 3-member committee, sitting judge of the Supreme Court, another judge of the High Court, and a jurist. And this committee will then give him a full opportunity to present his case before the committee. Once the report is ready, it will go to Parliament. Even then, it can be rejected by Parliament. You're aware I had argued on behalf of a complainant before the committee, where the committee was constituted. The inquiry was conducted with examination and cross-examination of witnesses on both sides, and the committee came to the conclusion that no case was made out, in which case the case was closed and the report was not tabled in Parliament. So he has the right.
Indira ji, you've been one of those jurists who has fought for transparency and cleanliness within the judiciary for a very long time, from state level courts to high courts to the topmost courts. Tell me, ma'am, when you look at this case, where a sitting judge of the Delhi High Court, when he takes his position that I do not know where this cash has come from, when he takes his position in this letter that apparently his daughter heard a loud explosion, and if all these facts are simply being brushed aside by the fact-finding committee, what does it tell us? Is there a constitutional anomaly that you find, or do you think that the circumstances are such that the judge had to be damned?
No, it's neither of those. The 3-member committee points out that the standard by which sitting judges are to be judged is of probity. Expected of them is something much higher than the conduct of any other civil servant or a person like you and me. Now, let's be very clear of one thing. Beyond reasonable doubt, the committee finds that there was cash, large amounts of cash found in a storeroom. Beyond doubt, the committee finds control and supervision of the judge himself and his family members. These two facts alone are sufficient to shift the burden of proof on the judge to explain A, how did the cash get there? B, where did it come from? C, it belonged. D, what steps did he take when he came to know about all this?
But what about the fact that there has been no Caesar which has been shown? What about the fact that what you're saying, large quantities of cash, do we know what was the volume of cash?
It doesn't matter what is the volume. What matters was stacks of 500 rupee notes were there. Now, there are eyewitnesses who have testified to the fact that it was there. Let's just focus on this one little issue. Stacks of cash were found in the storeroom. It cannot be denied. There is eyewitness accounts and there is electronic evidence to that effect, which has been admitted to by the people whose voices have been identified, whose faces have been identified. What explains the presence of the cash over there? That burden is on the judge. His explanation is was one of simple denial to begin with, then of absence of knowledge. All right, absence of knowledge, it has been brought to your knowledge. Now, what do we do from there? Nothing. So the committee concludes that he has fallen below the standard of probity expected of people to whom public premises have been given and who are in charge of the premises and in charge of everything that happens within those premises.
But here's my final question, Indira. If I take everything that you're saying, ma'am, on its face value, don't you think that in a case where the entire case was built up because the Supreme Court registrar, the topmost authority of the Supreme Court decided to upload all the allegatory material, all the video footage, all the email, etc., was put up before the public by the Supreme Court registrar itself on the Supreme Court website? Don't you think it would help everyone's cause if this inquiry committee report, this fact-finding committee report, if this fact-finding committee report was also uploaded by the Supreme Court? Why should that not happen, ma'am?
I cannot agree with you more. Let me put it this way. I think that the former Chief Justice of India, Justice Sanjiv Khanna, did very well with making the video public. However, I think that in forwarding this report to the office of the PMO without putting it up on the website of the Supreme Court of India is wrong, was wrong. Look, before we end this session, I want to tell you, why are we even discussing this? We are discussing this because we, the people of India, have a right to know whether our judges are clean or not clean. We, the people of India, have a right to demand a clean judiciary. And it was my right that this report should have been put up by the former Chief Justice of India on the website of the Supreme Court of India, which he failed to do. This report could not have been kept confidential. It should not have been left to journalists, editors, lawyers to go hunting around for a copy of the report and putting it out in the public domain. That's not our job. It is the job of the Supreme Court of India. They are accountable to make all this transparently available. So I cannot agree with you more on that.
Okay. All right, Indira, thank you so much. Thank you so much for joining us and sharing with us your thoughts on this entire matter. Thank you so much, ma'am.